everybody should be here. And, okay? And we're ready for the minor child, this is a return hearing on minor child therapy, behavior, and timeshare. Do you want to speak on this issue?
Yes, Your Honor. Joseph Kirchner on behalf of the plaintiff, Marnie Victoria, who is present. We had agreed back many months ago to do a temporary joint physical custody, joint legal custody order to give it a try. Ms. Victoria was hoping that the father would help and assist. And there were orders in place that he had to take the child to therapy, take the child to Sylvan Learning Centers, and not put the child with other people. And unfortunately, it hasn't worked out. And the child's not doing well. Yesterday, there were 2 behavioral incidents at school during his timeshare. There have been numerous overnights with family members, a trip to California that she wasn't even informed about in advance, missed appointments at Sylvan Learning Center, missed appointments with the child's therapist. The child is 13 now. It was a temporary arrangement. Our preference would be for the court to, given the circumstances, to end the temporary arrangement. Obviously, you'd have to have an evidentiary hearing to make it a permanent arrangement. I don't know if that's even being requested. Initially, there was a motion to change custody by father. He withdrew it, and then it was actually Miss Victoria who said, I would like some help if it could work out, but it hasn't worked out. So our request would be just to return to the status quo, take this matter off of calendar, and if somebody wants to file a motion to change custody, he doesn't even have a pending request. He had withdrawn his last request, and the order was temporary. Thank you.
What's the defendant's position?
So, Your Honor, it really is more what are the experts' positions. So the child goes to therapy with Maureen Zelensky. I found out this morning that she actually submitted a report to the court. I had a moment to speak about it with Ms. Roberts, the guardian ad litem. My client doesn't know what the report says. I don't believe that opposing counsel knows what the report says. So I think that this is a little bit premature until we can all kind of wrap our heads around what it is that the therapist is saying. I don't think that the guardian ad litem, the therapist, that what mom is asking for is in the best interest of the child. So I would either ask that this hearing be pushed for a week or 2 so that everybody can get on board with what the experts are saying, and that we reconvene.
So nobody has a copy of the report?
Only the guardian ad litem does.
And was it sent to the court?
My understanding is that it was. Is that correct, Ms. Roberts?
Yes, Your Honor. It's my understanding that it was sent to the court.
Could we check to see if it's in there? Well, I need to see it.
Your Honor, I could send it over to the JEA if you need that.
I'm sorry, I didn't understand what you said.
I could send it over to the JEA or the courtroom clerk if you need it. If you need it right this.
The clerk has it. We just got to get it
Okay.
to me real quick. Just relax, everybody. Just be at ease. Here it comes. I'm getting it. I think it's,
May I have a copy? No, I'm not. You can have a second copy.
no, it's a report from. Who's the author of the report?
Maureen Zelensky.
Sorry, Denise. The court-ordered therapist.
It's a child servant.
Yes.
I'd be better if there was a thing, nothing called blue jeans. If they would destroy blue jeans. This is typical on blue jeans where the parties are split up like this. But the lawyers seem to love it, so let them wallow in this unprofessional conduct. Did you find it? No. You want to send it to the court clerk?
Yes, Your Honor. Can you give me the email address?
I'll put it in the chat for you.
Absolutely.
Yeah, I think you can handle it now, so it should be good, thank you.
Joseph, good seeing you, sir. Seeing you, Dennis. Justin, take it easy.
You too, good to see you.
Good seeing you.
Your Honor, do you want me to copy counsel for the parties, or just do you want me to send it to the courtroom clerk?
Well, let me just look at it real quick, and then I'll let you
Okay.
deal with it.
Yep.
What,
Rachel, can you mute your device, please?
Huh?
Can you mute your device, your case isn't on yet, okay? Just mute yourself.
It's been sent, Your Honor.
thank you, just everybody.
You're welcome.
Yeah, come on in.
I don't know, Joe. Is he your employee?
All right, just send him back. He's been here before.
Okay.
Would it be possible for me to get a copy of this one?
Let me see, let me read it first.
Hey, come on in. Good.
Let's send this to the attorneys, please.
Ms. Roberts has my email.
You want me to do it, Your Honor?
Yeah, please, if you don't mind.
Absolutely. I'll send it to him right now.
Although I can get the counsel in the courtroom a copy. I'll do the one in the courtroom. You take care of sending it to the other attorney and to the other attorney.
If she sends it to me, though, I can save a copy. I'd appreciate it.
Oh,
I
send it to the counsel anyway.
I did, Your Honor.
Where is the minor child, by the way?
She's with the father.
Is she in school? Is she in school today? let me know, counsel, when you finish reading this.
Your Honor, Ms. Roberts read it to me, so I know what it says. I'm more concerned that my client doesn't know what it says, obviously.
Okay. Let me hear the suggestions you want to make as to what we should do today. Plaintiff, what do you
I mean, my
suggest?
suggestion is this is exactly what she was saying, that this is a free-for-all at his house, and this was court-ordered. I mean, he was given an opportunity to have joint physical custody in order to share in the responsibility of raising a child who is troubled and having troubles. And then when you see that he violated the court order, the last order, it says he's not to allow the child he's to spend the overnights, because this has been a consistent problem. They never even took the child to his home. And that he allowed the child to go a week to California without telling mom, that the child has been told the therapist that he's not allowed. My dad said, I'm not supposed to tell you how many nights she stayed with friends during his custody times, that he's been allowing the child to have a free-for-all all summer, which is exactly what she said happened. And what happened during the last exchange, he didn't even show up for the last exchange. She didn't know where the child was. She's texting with the child's at some person's child's house that she's never heard of. And he's saying, oh, you're ruining her fun. And she's, you know, we talked about this, or the child's telling her that my dad says he talked to you about it, and that she's allowing her to have a free-for-all summer, time with friends, lots of money to spend downtown summer, and unlimited access to her phone. When it was court ordered that there would be no electronics, he has not taken Monet to dance classes, he's missed 2 therapy sessions. This child needs consistency. Look, Miss Victoria wanted to give him a chance. She really wanted help from a parent who would be involved. She was hoping. I mean, it's a tremendous responsibility and time commitment, and it takes up all her time to do what this child needs. But she was willing to do it. She's still willing to do it, and she feels at this time, even though it's going to consume all of her time and all of her life, that she has to do what's best for the child. And if Mr. Victoria will not step up and father, which he has not done, time and time again, we need to just revert back to primary custody, and mom will bear the responsibility of doing what this child needs to do, including making sure she stays at home, taking her to her therapy sessions, taking her to her dance lessons, taking her to Sylvan Learning Center, and making sure that she's not running the streets wild, because this could end very badly. I mean, very badly.
What's the father's position?
Your Honor, I don't feel that everyone agrees that that's what's best for this child. If you read the recommendations at the bottom of the report by Maureen Zelensky, she's not suggesting that Monet should be taken away from her father. She's suggesting that both parents have failed to implement structure, that there is a lack of communication between the two of them, that mom wants to put her in a residential program. Ms. Zelensky doesn't agree with that. She believes that this is a parental failure, not a Monet failure. And she doesn't point fingers and say it's only dad's failure. It's also mom's failure. So, and I spoke with Ms. Roberts prior to the hearing. Ms. Roberts doesn't believe that that's what's best for the child. And actually what Ms. Roberts will say, if you ask her, is that the money should be spent on helping the parents to deal with Monet, not for court proceedings, which will result in Monet being with her mom and rebelling against that. And I would venture to guess her behavior would exacerbate, be 10 times worse than what it is now. Monet enjoys the time with her father. These parents don't communicate well. That is the issue here.
What type of visitation would the father have, or contact with the child, if we return to the status quo?
His visitation was, this was stipulated to back in the order from May 19, 2020 hearing. It's every Friday from 2:10 to 7:30 p.m. and every other Sunday from 9 to 6 p.m.
Ms. Roberts, what do you think?
Your Honor, this is the issue, that the problems that mom was having in her home, she's continuing to have. Monet is violent with her. She's sneaking out. She's stealing her credit card. She's kind of run amok. She isn't getting better in mom's care when we tried this schedule with dad. But to the same token, they're not following, according to my communication with Maureen Zielinski, what Maureen Zielinski is saying to do. So it's very difficult in this situation because Mr. Caratoni's right. If we don't do something, then the prospect of what's going to happen in the future for this child is very damaging to her. And the parents' lack of co-parenting and communication and cooperation, even in exchanging her medicine as recently as 30 days ago, Your Honor, is concerning because they need to be able to set aside their dislike for each other and really focus on the child. And part of what Mr. Caratoni is saying is true. Dad is not following a court order. Dad thinks that she should have more freedom. So at his house, he gives her a lot more freedom when Ms. Zielinski has said that's not appropriate. Essentially, that is giving her positive reinforcement that her behavior is acceptable. And nobody listens to and does specifically what the court-ordered therapist is saying to do. Maureen Zielinski is saying, you know, these are specifically what we need to be doing in both parents' houses, and neither of them do it to a T. They both kind of take and listen to what they want to, but they've asked the court to intervene. Most recently, before Judge Forsberg, there was a discussion regarding residential treatment, and we disagreed with residential treatment, so we agreed to Maureen Zielinski. I've spent personal one-on-one time with Monet before the last hearing, and I don't believe residential treatment is appropriate, but I do agree that because she continues the behaviors that Judge Forsberg addressed, including stealing mom's credit card and charging thousands of dollars, Your Honor. This isn't like one charge. She's charged thousands and thousands of dollars on mom's credit card. She uses it for Uber. She orders food. She gets clothes. She buys things from Victoria's Secret. So this isn't one little charge on mom's credit card. This is a pattern of behavior, and that is theft. And I think she almost needs a wake-up call, which is what I've been saying from the beginning. And I don't think mom or dad maybe are objectionable to that. And that is what Maureen said in here, that we should consider that as kind of a wake-up call before we move to any residential treatment. And I support that, Your Honor. As far as where she's at with which parent, until they're both going to follow what the directions are from the therapist, I don't know that changing the current schedule has any benefit for Monet, because they both have to agree that they're going to follow the schedule. If she gets RPC'd at school, there have to be consequences regardless of whose home she is in. We can't give her positive reinforcement and tell her that we're going to let her, you know, go to downtown Summerlin or give her money to do things when she hasn't earned it. And I don't think when she's with dad and she's stolen mom's credit card that he should not have consequences at his home for that behavior. It's unacceptable. If you or I or one of the other counsels stole somebody's credit card, we would be sitting in jail. And at 13 years old, for her to continue this behavior, because this has been going on now for all year at least. So for 8 months, Your Honor, we've been dealing with this, where she's been stealing mom's credit cards, mom's canceling them, mom is hiding information so that the child doesn't have it, and she's continually having the information, is concerning behavior, because it's a slippery slope. If it continues as 13, then I can't imagine what it's going to be when she hits 18.
What about a stint in juvenile detention?
I'm not opposed to that. She's scared of that, Your Honor, and I think it might be a wake-up call that she needs. I know I talked to mom on the phone about this, and mom said that the police offered either that as an option or some diversionary classes, and I'm not sure if my last conversation with her was August 2nd, if she had talked to the police regarding what the diversionary classes would be. If the court wanted to, maybe you do the diversionary classes as the first step, and if she uses the credit card again, even one time, then it's juvenile detention. I will tell the court, Judge Forsberg brought her into the courthouse and had a conversation with her. It probably was about 30 minutes, and explained to her exactly the things that we're talking about, and that her behavior is not appropriate. The violence towards mom is not appropriate. The stealing is not appropriate, and it's continuing since our last hearing before Judge Forsberg.
Your Honor, could I speak for a second?
Sure.
Thank you for your time. Listen, I don't agree with juvenile hall at all. Monet doesn't have these issues with me at my home. Obviously, there's no respect with her and Marnie, and that's always been the relationship. That both of their relationship is toxic. When Marnie and I have been on talking terms, Marnie agreed that she needs therapy with Monet, and I let Maureen know as well. So as far as juvenile hall, I mean, you're gonna put my daughter in the system as a wake up call, and she doesn't need that. That's why the timeshare, the week on, week off, has been great for Monet to go about her life in a positive way, as well as me helping her, with things with Marnie over there, because it is, I agree, it's not right, but Marnie cannot parent her at all. It hasn't worked. And Marnie's first line of defense, Your Honor, is call Metro and put her in juvenile hall. That's wrong. And so that's all that I have to say.
All right, I'm going to.
Thank you.
I'm going to return this issue to the status quo with mom having primary custody. She has to continue with the therapy, and I want you to put her in the diversionary programs rather than. I was thinking that maybe a short stint in detention would be appropriate, but I'm not going to do that at this time. I'm going to advise defense counsel, or I should say father's counsel, to file a motion to change custody, and that way we can have a hearing down the line. I want to see how this works out with mom having the primary custody, dad still having the visitation rights that originally had, and then report back to the court. We'll have the guardian ad litem report back to the court as to how the diversionary programs are working, along with the therapy. So it'll be both therapy and diversionary programs, and a return to the status quo with father making sure he has visitation rights. That way,
Your Honor, I'm sorry, I don't mean to interrupt, but the visitation rights, first of all, obviously, we're going to put on the record that we strongly disagree, and I don't think anybody other than mother believes that that's what's best for her. But secondarily, my client had extremely restrictive visitation with the child under the previous order, not even an overnight.
then please
And
file a motion to change that. I need a motion and an evidentiary hearing on that issue. I want to go back to the status quo and start over. This isn't working. It's apparent, and the choices that I have as a judge are not very tasteful, to tell you the truth. So let's go back to where it was before. I'm ordering the diversionary program per the guardian ad litem, suggesting it. I'm not doing the stint in detention because I think that's a little bit too harsh. I still want the father to have visitation rights, but they're restrictive, but that's what motions are about. So I'm going to continue this matter for 45 days to see where we are in 45 days.
Your Honor, when you say back to where we were, there was a pause on child support, all those things go back.
Everything goes back to status quo.
Okay, and then do we get a referral for the diversionary program from Your Honor?
How do we work that, guardian ad litem? In other words, you're familiar with it, so.
Your Honor, my understanding is that Marnie just needs to follow up with the police and indicate that her preference is the diversionary program rather than juvenile detention. And then if that doesn't work, she can communicate with me, Your Honor, and I will communicate with Judge Forsberg's chambers to figure.
With mom's counsel on this to make sure that it happens, because I don't know if she
Yes, Your
can
Honor.
get this
Put
on.
it in a court order, I think, because every
Please.
time you call the police, they say, "Oh, you have a family court matter."
Give me a good, strong court order that we can sign.
Yeah.
Okay.
Okay.
And I think this is just temporary. I'm not firm on anything that I ruled today, except to give me a chance to breathe a little bit in this case. And if Judge Hardcastle comes back, she's a real pro on this too. So we'll see where she is. But prepare an order.
Thank you, Your Honor.
And I understand about the objection of the father and father's counsel. I understand. And please file whatever you feel should be appropriate to visitation or change of custody, and we can get that heard too. But let's continue this. In fact, let's make it 60 days.
Yeah, we're gonna need time for a court order diversion.
Yeah, I need some time. I need some time too. 60 days.
October 18th at 8:30.
I'm sorry, I didn't hear the date.
October 18th at 8.
10 o'clock or 10:30?
8:30.
8:30. Okay, thank you.
I'm going to make this report part of the record too, please. Thank you, everybody.
Oh, Your Honor, I'm just checking my calendar if I may. I have a Supreme Court settlement conference that day, and I'm on a stack. Is there possible to get another date?
Sure.
October 20th at 8:30.
Still on a stack, but I'm actually out that day too. Can we do it next week? Would it be possible? Sorry to be doing
Sure.
No problem. October 25th at 8:30.
Yes, that'll work.
Let's get this order as soon as possible so we can get this diversionary program.